This has proved to be a truly interactive session. I think the time is almost up. Mr. Stipanowich, maybe we should have a couple of more questions, or what's your suggestion, please?
Very good. I would like to turn, if I might, to my colleagues on the U.S. panel to respond very briefly to any of the issues that we heard about. Among other things, we heard about the important role that mediators play in addressing sensitive personal issues, face-saving, things other than purely economic issues. We also learned about the dynamics, the cultural dynamics of processes which include mediation as well as arbitration, which is something that is occasionally done in the United States, and I personally have had experience with it, but I know that we have debates among ourselves about the appropriate roles that mediators should play, and indeed it may be appropriate in a future session with our friends at the Beijing Arbitration Commission to explore mixed roles more fully. Having said that, we heard about these things as well as confidentiality issues and enforcement issues. And let me just ask each of my colleagues briefly if they would like to take one element of what they heard and respond. And Nina, let's begin with you.
I'd like to address briefly two things. The first was the importance of saving face and having parties resolve their disputes in a confidential, private way. I think that this is very, very important, and it's one of the reasons why people are in conflict, that they feel that they have been hurt. It was mentioned before about revenge or anger, or you've treated me inappropriately, and I think mediators can be very effective in helping parties with those issues. I think sometimes a mediator in a separate session can help a party frame an apology in a way where they are not losing face in that apology, but acknowledging the pain that they may have caused to someone. And I think we can help as mediators to coach or to help people know the importance of that. I think sometimes if we know the parties have a very hard time listening to each other's offers, that anything that the other person says is wrong or that they distrust it, that we as mediators can frame offers ourselves rather than having it come from one party to the other. Because if it comes from one party to the other, maybe one of the parties will feel that they are losing face by accepting it. It might be a good offer, but because of how it's being said by a party, they're not willing to take it. So I think in that way, we can work very much in providing the harmonious and the good place for people to deal not just with their legal issues. The second issue that I just want to address very briefly is the mediation arbitration issue. And it's interesting because although now I do mediation all the time and I don't do any arbitration, when I would do arbitration at the end, I would say, I'm going to go into the other room and I'm going to write up the basics of my decision, and then I will be right back. And I would come back and I would say, okay, we have a little bit of time left. If you want to try to resolve this, not knowing what my decision is, but still having control yourself over the outcome, would you like to do that? And then I would look at them and say, how do you think you did in the arbitration? And they would get a little nervous, and over half the time they would then mediate a resolution to their case because they wanted to be able to control it rather than wondering what I had done. So I think sometimes we have mediation followed by arbitration, and sometimes we have arbitration followed by mediation.
Linda?
I would like to also address the mediation-arbitration combination, but from the standpoint which Tom was discussing, which is the debate about whether or not it's appropriate to have those two things combined. And one of the issues that has been raised when this issue comes up, and it is something we talk about a lot in the United States, is that the mediator is privy to all sorts of information because of the informal or less formal nature of the process, because it is not simply limited to the legal issues. And that information gets used, this is what people discuss, if in fact they have to render an arbitration award. There is also some controversy about injecting a decision maker, even though it does give you finality, which is a big advantage, as many of our colleagues in China have discussed, about having a final decision rather than empowering the parties and having them feel the pressure to reach their own decision. The second point that I want to address goes to confidentiality, which we have not had a chance to address in length, at least in this session, and my hope is we will be able to in future sessions. And I'm most interested in this area because all of the mediations I do, confidentiality is a deal point that is very, very important to the parties. And one of the issues that has been raised in the United States, especially, for example, in product liability cases, is when confidentiality is used in the settlement, what about the public interest in knowing what happened? So, for example, when I mediate a case with a defective product and the manufacturer settles that with an individual or even a class action, which I also handle, what happens to the public interest to know what was discussed, and to the extent that the manufacturer can have a settlement by paying money and hide that information from the general public. So this concept of confidentiality, facilitating individual agreements, but perhaps having a negative effect on the public, I think is something fascinating that I hope we will have a chance to discuss again and more with you.
Thank you, Linda. Peter?
I will comment on two things. I very much like Mrs. Zhang's comment that it's a good idea sometimes to critique the lawyers. And I will look for opportunities to do that in my next case. Finally, though, I was also very much enjoyed thinking and listening about the idea of the enforceability. And while within the United States a mediated agreement is largely enforceable, one of the commentators made the very interesting point as far as internationally, the enforcement of an agreement, a mediated agreement across boundaries, could become more complicated. And I have done a case, it's been many years, to where the parties mediated to within a very, very small range, and then they asked me to arbitrate, and they asked me to arbitrate at that point for the purpose of enforcement. And this idea of hybrid processes, especially with the conventions of the enforcement of international arbitration awards, becomes very interesting as far as mediating, but then almost issuing the mediated results in the form of an arbitration award, so that there is easier international enforcement, is something that I had not considered before this conversation, and I am in your debt. Thank you.
We had also debates on the combination between mediation and arbitration. I think the experience shows that we should make a clear distinction between mediation and arbitration. When you act as a mediator and forget arbitration, that your professional ethics ask you to keep a full confidentiality of the matter. And the matters disclosed during the conciliation must be kept confidential and disregarded when arbitration failed. If you resume arbitration only on the face of the agreement and also on the based on the legal matters, so you cannot go beyond that, go to the other information. So that's a strict requirement. Otherwise, we will make the worry of people. They don't cooperate with you. Thank you.
Well, as I said earlier, this has been a truly dynamic and interactive session. And I think that both parties have identified issues that that can serve as future topics for the future dialogues, and I'm sure we'll be doing that. So on behalf of the Beijing Arbitration Commission, we thank the Straus Institute for your time and expertise and insight. And so I propose that we adjourn the meeting for today. I know the U.S. colleagues will be disconnected, and then the BAC will continue its own session. Thank you very much.
Thank you again.
Thank you.
We appreciate it.
Thank you very much.